Let's switch gears again and go back into this procurement and we'll bring Attorney John Brown back on, who has been following this emergency procurement very, very closely. And, well, good morning, John. Here with Sabrina, of course. Good morning.
Good morning.
Good morning, Sabrina.
Good morning.
Chris. Good morning, Will.
Yeah, so you had actually wrote a lot of your thoughts on this down, and we're going to end up sharing that on our site, but we got you here live. So, again, if you could, and I know it's difficult to summarize because it's a very complicated issue, but what are the thoughts that you have on the governor's use
of her superpowers?
Her superpowers, right.
Title 10.
It really goes back to the memo where she tried to rewrite history. The memo to her directors, Lester Carlson and Edward Byrne. And she tries to make the case for procurement, and I'll come back to that because I want to get into, first of all, to what I think is a new topic that hasn't been mentioned by anybody. And this is where, this is May 4th, I guess, was the date of it, the 8th, which is about 6 weeks after she issued her emergency procurement. She's finally getting around to explaining what happened. And in it, she says that the federal government has directed money to Guam. These funds must be used by the executive branch. Oversight of the use of the funds is given to the federal inspector. The funds are within the exclusive management of the executive branch. And she cites to a District Court of Guam case in 1978 saying that all grants and appropriations made by the United States to the government of Guam, where the grant or appropriation provides 100% of the funding for a specific project or purpose, and which grant or appropriation makes no provision for local legislative control. So in that case, the government of Guam has 100% of the responsibility, is what she's saying. That's not exactly everything there is to it. There is a code of federal regulations. That's a universal code. It's the Uniform Administrative Requirements for Federal Awards, and it's at 2 CFR 200.302, Financial Management. And that's sort of the introductory statement that each state, and it would include territory by their definitions, must expend and account for the federal award in accordance with state laws and procedures for expending and accounting for the state's own funds. So you can't just hide off on saying, well, the feds have agreed to this. We have an obligation to expend those funds by local law. Now, it does get a little bit confusing because when you get down into the nitty-gritty, into the weeds of it, it does authorize some limited federal use of federal procedures. The main difference between the federal procedures and the local procedures are the thresholds of applicability, the amount of money at the stake. Our emergency procurement doesn't have one, but small purchases, for instance, has a $25,000 small purchase, because for Guam, that's still pretty up there.
Right.
But the feds, I think, it's $250,000 as their small purchase. It's a significantly more, whatever the number is. And so, there are a lot of people on Guam serving in the government and private industry who are used to federal procurement, really like those small purchase things, because they are like our emergency procurement, virtually without much oversight and prudence, good governance. So in section 200.317, that same 2 CFR, says when procuring property and services under a federal award, it reiterates a state must follow the same policies and procedures it uses for procurement from its non-federal funds. And then it sets forth standards about what the local government has to do whichever way they go. And those standards are pretty much our same standards, with again, the primary difference being just the amount of money that you can utilize in those different methods. So I'm not convinced that the statement made by the governor that it was hers to do as she alone wants to do is accurate. But based on that, she said that she therefore instruct compensation contemplated in the attached agreements and invoices shall be paid subject to any necessary reconciliation. And where services continue to provide, I instruct that future invoices be paid in accordance with the terms and conditions of the agreements. So, I mean, she's really put her anchor down on that subject, and I think it could use a bit more ferreting out. There are occasional contracts that we have, or monies that come to us by way of grants particularly, and also federal funds, it has to be admitted, from federal programs, like some of the HUD programs. Those we're just acting as an agent to spend the money in the way they want it acquired. But this money is given to us pretty much without strings, other than broad brush statements of purpose and utility. Yeah. So I wouldn't be quite so sanguine as she appears to be that as she says, in accordance with Executive Order 2020-13, all agreements and invoices involving services covered by this memorandum shall be posted on the website. Well, that's good. That's all transparent in the government, but that's not enough. You have to have some semblance of a method. Mm-hmm. What was the method in this case? And that brings us back to her other superpower statement. And she says, even in the best circumstances, typical procurement is time-consuming, and it was readily apparent that the emergent conditions made it impracticable, sometimes impossible, to utilize the normal process for acquiring goods and services. We recognized the immediate need to secure quarantine facilities, and I instructed the efforts to be made to secure the same. We acquired facilities. Additionally, we required necessary support services for the facilities. So she's gone out on the fundamental authority that she says exists in the local law, Title 10, Section 19403A1. Repeats that one over and over again. That was what she cited as authority when she issued the first executive order with making a state of declaration of emergency. And she says, I invoke that authority which allows the governor to suspend the provisions of any regulatory statute, any prescribing procedures for conducting local business, or the orders, rules, and regulations of any. So she spells it out right there what the law says. It's not just any statute, but she keeps saying any statute. It's a particular statute, one that prescribes procedures for conducting local business. Well, the emergent procurement, no procurement law does that. She can't just set aside a procurement statute, because it is not one that is prescribed for prescribing procedures for conducting local business. Now, that may have given her cover to say that certain businesses have to be shut down, and in consequence of which, if they disobey the orders, then the business license can be taken away from them. So that would be a statute prescribing procedures for conducting local business, at least arguably. But certainly not the procurement law. She can't just ignore those. And not only that, this statute isn't just it doesn't grant powers. It allows the governor to ignore powers, to defer, suspend the laws. But if you go back again and look at it slowly and carefully, as I've done many times now, it says the governor may, through an executive order, suspend. And I'm going to skip over. I'm going to give you the key words: to suspend any statute for conducting local business to the extent that that statute would prevent, hinder, or delay necessary action, including emergency purchases. Now, it doesn't say. It gives her certainly the power to suspend that statute, that rule, that regulation, but it doesn't say. And I'm also giving you the power, the right, the executive power to suspend emergency purchases. It doesn't exactly say that. And if you did suspend that, you'd be suspending the whole procurement law. And is that appropriate? But her focus on including emergency purchases is not wrong. She says, though, that defines the kind of action I can do. I can engage in emergency procurement. The critical word here is to suspend. She can suspend a statute that hinders this necessary action. She can't undertake emergency procurement. She can suspend a statute that hinders that action that she wants to take. So it's been artfully crafted to get the result that she obviously wanted or was told would be there for her.
Right.
I don't see it. This is the authority she keeps citing is only an authority to suspend. It does not say you can make emergency purchases. Now that's what the procurement law says. It's in the procurement law. It says that notwithstanding this provision, the following parties may make or authorize others to make emergency procurements. That's an authority to conduct a procurement, to make or to conduct.
So who has the authority to make the emergency purchases, procurement purchases?
It's the CPO, the Chief Procurement Officer. Chief Procurement Officer is in charge of procuring or supervising the procurement of all supplies and services. So if you're after supplies and services in an emergency, you go through her because the statute continues, or the Director of Public Works, but the Director of Public Works only has responsibility over construction,
right,
not supplies and services. So,
John, let me just ask you: does it say anywhere in the Emergency Health Powers Act that the governor has the authority to appoint her legal counsel to run point on procuring or whatever, putting out contracts that don't get signed?
Negotiating, yeah. I mean, who's supposed to be doing that?
Well, there isn't. In fact, the whole law is kind of silent on that. But let me just point out that the governor's procurement authorities are limited. They used to be everything. The first procurement law passed by the legislature overturned the the regulations, procurement regulations that the governor had adopted by executive order under the Organic Act powers. So the legislature said, no, we're going to take that power away from you from the Organic Act, and we're going to give it back to you. Now you can promulgate procurement regulations, but it's under our authority, not the Organic Acts. And that was back in 1957 or 57, the regulations 58 when the law was passed. And eventually the law was separated so that not all procurements in one office. It was separated. DOE and GMH got separated out. They each could conduct their own procurement, but in each case, under regulations adopted by the governor. So the governor chose all this stuff, and then in 1982 we had a massive law that came into effect that comprehensively took legislative charge of all procurement. And in that law, the first section in it, I think there are 28 sections. The first section was the new procurement law. The second section repealed all authorities, statutory authorities that had been given to the governor prior to that time to make any regulation of procurement. So that the governors have been divested of procurement involvement for a long time. Now their agents, their agency heads and everything, they conduct it, but not directly through the governor's office. So I really can't tell you one way or the other whether the governor's office as an entity has procurement authority.
Okay. So just in the most simplest terms, because you really went really technical.
I know you're waiting for that,
just
John.
Layman's terms, based on your experience, your expertise in emergency procurement, a read of the Emergency Health Powers Act, of Title 10, of emails by Haikien, Sofia Diaz, other people in the Attorney General's office with Charles Esteves, everybody. Your read of everything that transpired with these quarantine isolation facilities was emergency procurement. Were the protocols followed? Did the governor have these superpower authorities, which she cited in the May 8th memo?
Right. Is it illegal, I think, is another good question to throw in with Sabrina's.
Yeah. Well,
keep it simple.
I don't think that the governor had the authority to send out any counsel or anybody else to conduct an informal process. Either they were operating under the procurement law or they were operating without a law. And I think at the end of the day, we've shown that they, once Mr. Stevis got into the game and the CPO stepped up to the plate, they were doing it strictly by the book, by the procurement book. And they were conscious of that. The other things that were done, the money that was promised and not paid until just recently, the services that were rendered without a written contract, all of that.
Wait, there was a written contract.
It wasn't signed.
Right.
It wasn't a completed contract. There's, that's just a dead tree if it doesn't have a signature on it. So there was no contract. So there were informal agreements. The procurement law requires written agreements. The documentation is the key to this is government. You got to document everything.
Okay, let's stop there then.
Right.
This is a dead tree, but May 8th, the memo. I have my Title 10 superpowers. Pay out those invoices.
They were paid.
And they were paid.
They paid $1.7 million out to these people with dead trees.
So what does that mean?
Let me just tell you something that's illegal. Probably not. But who's going to do anything about it? If it was a breach of the procurement law, that is only enforceable by a protest, and nobody has protested. And not just anybody. You and I can't protest. It's got to be somebody who was a bidder or a prospective bidder. And they've got 14 days from the time they figured that out to protest. It hasn't been done. So maybe it's illegal, maybe it's not, but it's not going to result in any legal action under the procurement law.
Mm-hmm. There was
Is that the end of the game? Well, there is a curious law. It's called the Proper Expenditure of Government Funds Act, or something to that effect. It's in 5 Title 5 GCA's Chapter 7, and it allows any citizen, any resident of Guam to sue somebody who acted without authority and get a personal judgment against that someone, and it specifically says, including the governor, for not that the person suing gets anything out of it, but they can have that person who's expended government of Guam funds without authority to pay it back to the government. The personal liability to pay back everything that was expended by a violation of the scope of authority. Mm-hmm. So there is something that can be done. What we have seen in the past, because Guam has been rife with all kinds of procurement violations, is that a year or two or three or four later, the public auditor comes out with a report saying everything that's been gone wrong, and somebody gets a slap across the wrist or a kiss on the cheek. I'm not sure which.
We had a comment here, John. What about from Rachel? What about taxpayer standing for unauthorized expenditures?
Well, the statute I'm talking about, any resident has standing. That's what the law says.
Right.
Any resident can bring this action, and there may be a taxpayer statute too, but of course, it being a taxpayer one, it won't have the breadth of getting an action as the taxpayer. But the taxpayer, even then, they're not going to. The taxpayer who brings that action doesn't get paid anything. There may be a whistleblower, but we all know about it, so there's no whistle blown. And we do have a very meek whistleblower statute. So, and I just want to step back also one further step and see it from the governor's eyes. The governor's eyes were bulging. Her heart was pounding because this menace is on us. It's in our face. It's in our homes. And it's in our major industry. And it's going to, and all the world is saying, we have to social distance. We have to shut down. Italy was shut down. Spain was shut down by the time that we shut down. A lot of that was happening. And so she stepped out and did this. She undertook some exposure, some very big exposure. She should just admit that that's what she did and not try to make it right, because it wasn't right. And I don't, in my mind, and you can't make it right. But it was, to me, I'll niggle with some things like those euphemistic road closures. To me, she did things that needed to be done. It was ham-fisted, but it needed to be done. So in contract law, not tort law or criminal law, there's a concept that no harm, no foul. You can't sue somebody for breach of a contract, even if they maliciously, with intention of forethought, breached the contract, because there's no suit in contract unless you are you have damage yourself. And the whole procurement law is built around principles and contract law, principles of governance and contract law. That's procurement in a nutshell. So I come from that side, and I don't cast blame. I cast the notion that it was done illegally. But I'd like to really myself get through this, admit that it was wrong, fix this, that make sure that this never happens again. We need to either cure the health law to keep the health law out of procurement, or expand the procurement law specifically to take into effect the health powers law, which requires a declaration of public health emergency, whereas the procurement law just says a declaration of emergency.
This is really interesting, John, because what's been happening is you're saying that, I mean, for all intents and purposes, it's illegal, but what has been happening is the governor has repeatedly cited these powers as the justification and the reason why she's able to do these things. I mean, repeatedly. I think in an average press conference, she mentions it like 5, 6, 7 times.
Yeah, I wish she would just get off that.
But I feel like she's doing it because she's trying to beat it into her head, and you're right, no one's challenging it.
Yeah. And the longer time goes by, the less chance that she can. So, and I think one reason it didn't get challenged, I mean, we all grumbled about the things that she did, in particular those road stops.
The checkpoints?
The checkpoints, yeah. That was a grumbling thing, but we obeyed. We did it.
Yeah.
Because why? Because she may have been technically wrong, but she was doing some of the right things. Some of it ham-fisted. If I could accuse her of anything, that's what it would be. But the illegalities are very technical. They're nuanced. I had to read the law 2 or 3 times myself just to try to sort out what it says and how it integrates with the other laws. it's behind us, but it's going to happen the next time. Sure as God made the little green apples, there's going to be another pandemic. Maybe not in my lifetime. Don't have that many decades left, but there will be another one, and we need to come together and record our experiences and our observations and what could have been done better, what could have been done without threats of a $5,000 fine and a year in jail because I didn't have a mask on when I went into a store. Things like that. That's just nonsense, and it pissed off a lot of people. I was one of them.
Yeah.
I sound like I still am.
Yeah. A little bit.
But I guess I could do a Sabina and just go quiet.
Oh, wow, you really pay attention, John.
Well, that's what my mom always told me, and you mentioned it. I said, God, that just sounds like my mom. My mom said, if you don't have anything good to say, don't say it.
Yeah, be quiet.
Are you there?
I was like, hey, yo, Senator, where you at?
Yeah.
Well, John, thank you, man, and I want to keep you on. Obviously, I know we shoot messages back and forth, but definitely want to bring you on. Maybe early next week after this oversight hearing. Are you going to be watching the hearing tonight?
Yeah, I have been providing advice to the committee chair.
All right.
So I would be interested in seeing. I mean, I'm not going to be there. I'm not taking part in it, but I'd be interested to see how it goes.
Well, that's good. Good to know, John. Appreciate your time. And again, this is Attorney John Brown, the author. Like when we say he wrote the book on procurement, we mean it literally. He's the author of the Guam Procurement Process Primer. And you've also got a blog, John. You know how to work a blog?
I'm old school. That's the only thing I had. I was doing blogging back 15 years ago.
Right.
And I started this procurement blog when I started teaching because I have a lousy memory. I can't remember things. And so I take note of stuff. And if I put it in the blog, I can go back and find it. I know I did something about that sometime, and poke around long enough, I can find it. It's got a lot of good information in it, and it's been recognized by the George Washington University's law school as one of, I think they don't even have 24 blogs that on that topic on government contracting. So I'm pretty chuffed at that.
Yeah, that's pretty cool, John. And again, I think that. When we bring you on, we're bringing you on and letting you speak from the realm of your expertise. And so that's why we really value your perspective on this. And we hope to talk to you again next week, John.
Okie dokie.
Okay.
Very good.
We'll see you.
Take care.
Yeah, bye all.
Okay. Wash your hands.
Wow. That was deep.
That was pretty deep.
Yeah. I think maybe if people can read your... Actually, I actually do recommend that you read it. Jason provided the link in the comments.
And it's pretty plain language, the way he wrote this down. And
I mean, I had to read it a couple times.
Right.
And I'm still kind of rereading it.
And I think a very fair assessment. I mean, he's coming down and saying that, it's illegal, technicalities and whatnot, and, questioning